for pronouncement of judgment in criminal appeal jail 74 of 2020.
The appeal has been dismissed. We record our appreciation to the assistant judge learned amicus.
You don't let it last. In item number 13, which is fixed for here. Last night, when I went to the record, I find that the cross case record has not been found. So I think because the cross case record has to be worked out from the court of the district and session just to be.
I give the number.
GR case number 774 of 2013.
Yes, madam.
Arising out of Dhubri PS case number 834 of 2013.
The BD for learned senior counsel for the appellant has informed that there is a cross case being shown, the records of which would be necessary for a fair adjudication of the matter. He accordingly prays for calling for the same. Also heard Ms. B. Bhuya, learned APP. Masan Para. Praise print is accordingly directed to requisition a scan copy of the.
No, original, it's disposed of.
Is it disposed of?
Yes, sir. Yes, disposed of.
To call for the record, call for the record of the aforesaid case, as it has been informed that the said case has been disposed of.
Disposed by the learned session just Dhubri.
Disposed of by the learned session judge Dhubri.
But may be a fixed date,
the matter may be listed for orders immediately on receipt of the said records, so as to fix a date of hearing.
Yeah.
It will be called from the
Session judge Dhubri.
office of the session judge. Okay.
Maybe.
Yes.
So I take the item 7 later. Why it's suspended right now? So let's say have to do it.
Yes, madam. What has happened? Hope nothing is serious. Hope nothing is serious.
So it's happening for time right
Uh, a prayer has been made on behalf of Riaz Mukhtar for adjournment on the medical grounds in his family. Para also heard Ms. B. Bhuya, learned APP Assam. Para matter is accordingly adjourned by 3 weeks. Urgent listing of what matter? What is the stage?
Given the direction that we should have filed the separate appeal for that, and we have also filed the RA for reserve fundamental. It should be
What is the stage now? The delay has been condoned.
we have to do whatever we have just filed the RA for reserve. It has not come.
It has not come. It will come up for today is what, Friday, next Wednesday.
Okay.
In this case, I have filed IA for bail. 7 PM happened to
April 13th. 13th of April is gone. Long back.
That's been good. We have
You may have it in 2026. That is possible. We cannot reverse the clock. When do you want? Tell us. Is it a fresh IA? Today is what? 25th. Yes, we can have it on next Friday.
That's right.
Thirtieth of April. That's what it is, 30th April. And 30th is there. I thought today was 30th. Yes,
There is a rush. So at that moment, I don't know what day.
10, yes.
Like, so don't see how it's without the best improvement.
Okay, have you informed the other side?
Yes.
You have informed whom? There are respondent number 2, private councils are appearing. Have you informed them?
No, like,
You have to inform them, then you make a mention, we'll allow, okay? Ask madam, she'll advise you what to do. DK Bajda and I'll ask.
but there's a- there is a listing of criminal voters.
What is the stage?
Respondent is not a ground last, last day of the quarter. That.
POCSO conviction and the POCSO. Yes, Friday next.
Must be.
Item one,
We'll issue notice on unregular condemnation. Why a senior is necessary? You will be good enough. Who is the senior? You be here. We'll issue notice.
item one,
You are legally counsel. Here. Legal counsel. LDG. Appeal. LDG. Call for the report. He become understand one, state. 2 steps. To be routed through the office of the PP. Steps within 2 days. 6 weeks for receipt of record. As well as for report on the service of notice upon respondent. You have an IA also. I notice, this is an application under so. The connected appeal has been admitted today. There are issue notice, but you can steps slowly to the office. Already records not here. List of the 6 for report on service, as well as for filing objections if any.
item two,
Yes, yes.
Applicant's conviction under section 303 for life.
Your Ahmed.
It's
Ahmed. Ahmed. Huh? How many appellants? That was 302. Ahmed. Appeal, so admit for the record. Only one respondent. A become validity. Accept notice on behalf of the state respondent. List of the 6 weeks. That's not again. List of the 6 weeks for receipt of record.
There is a higher.
You put it in. This is an application also in collected admitted. Issue notice. List of the 6 weeks for filing of objections.
item three,
Conviction under section 302.
You have made the informant a party.
Yes. As that party.
Why? Okay. And 302. You're taken to. That's 1/2. Steps to be taken in the manner prescribed. It will through the office now. But can you active 6 weeks for service report as well as for the receipt of record. Yeah, there is no IA.
No,
You take steps.
item
Steps
seventeen,
within to working.
supply list. 17.
Criminal activity. Effective highest character, simple judgment order.
Madam, where were you yesterday? Yesterday, where were you? If we overlook the cost list, what will happen? First matter, you should be aware.
Yes. Rashid,
On the
302.
302,
Like it.
as Chakraborty,
Yes, Rashid.
that is the respondent number 2 was about box on like 2 steps, normal step in the manner prescribed. You have an IA?
Yes, sir.
Okay.
That's basically-
Or the A become, no? Take steps, 2 working days. 6 weeks. No, from IA comes objections if any.
Item 4,
Yes.
Take time for solution, madam.
Hmm?
So my husband tried that it is for final hearing and then case.
What had happened, there was some negotiation on the Rashid bank. And I did some money also in between my friend and her. Thereafter everything stand. And amount settled was it is written some of the office. Then less
No, if you are agreeable on certain points, inform us, will, Mrs. Sinha,
But till then, my lord, sometimes time is going on, my lord, I have no other concerns.
I have taken loan also for.
So my other, before that, my lord, my pending maintenance was given. Pending maintenance was more than 3.5 lakh. I informed my land.
no, Ms. Chakraborty, the amount which is presently pending is itself a substantial amount. So on your own interest of your client, you should take a positive step of resolving the matter finally. Because paying in installments will only add to your burden. Pay a reasonable amount, Mr. Sinha, I think will be
Yes, my lord.
agreeable, agreeable. Otherwise, you have to pay this 3.5, you cannot escape, you cannot. This you cannot avoid. No, we'll do one thing. We'll do one thing. No, Mr. Sinha, Mr. Chakraborty. Matter is of 17. We just cannot adjourn this matter. We'll direct listing of this matter for hearing, and we'll say that this will, in the meantime, out of court settlement, an endeavor can be made, which will be considered. Okay?
In the meantime, I love pending maintenance management. That's why I deducted out and then I maintenance, no problem. If there is pending maintenance, my lord.
Pending maintenance is how much? Yes, when can you pay the
More than
pending?
3.5 lakh.
Within 343.
50,
See, we take another step. We'll have this on Friday next for orders. If you come up with some instructions on Friday or Wednesday, Thursday next for orders, come up with instructions that you are finally settling the matter. Otherwise, you'll have to pay the interim maintenance, and we'll fix for a hearing.
yes, my
Okay, we still give you a chance. We have it on, madam, we'll have it on 5th, Fifth.
Second and fifth, difficult, any other.
6th, we give you some more time, 6th,
lord.
7th, 7th, okay. Third, Sri BP Sinha, learned counsel for the appellant, as well as Ms. P. Chakraborty, learned counsel for the respondent. Full stop. The learned counsel has informed that pursuant to the order dated 17/2/2025, though certain steps were taken for resolution of the matter, the same cannot be resolved. Full stop. The Sri Sinha has also highlighted the aspect of the pending maintenance amount which is yet to be paid. Full stop. Sarah? Considering the above, a further opportunity is granted to the parties to finally resolve the matter amicably. And the matter, full stop. The matter may accordingly be listed on 7th of May 2025. It is however made clear that on the failure to reach at any amicable settlement, this court would pass necessary orders on the pending maintenance.
Item five,
So, Bora,
Yes, the second is just for the service. So the priority holder from the road.
served or not? Served. Well, affidavit filed.
It is carried, basically.
So given to the brother. The respondent has not appeared till now. Matter is of which year? 2018. But the order of 5/6/2024. It says something else. This affidavit was of May 2024. Matter has come up thereafter. Why are you taking us to the affidavit? Why don't you deal with the order of 5/6/2024? Fresh justice was directed to be taken. Did you take fresh justice? When?
Nineteen
1999.
That was not there.
Who has taken? Who has? 1999. Let me see. It is given to the father this time. What do you say, father receiving notice? Is she staying with the father now? The service of the brother was not accepted by the court. Now for the father. Why aren't you able to serve on the respondent?
He was not present.
She was not present. I think that would be the best. But you can take instructions. Paper publication is a costly affair. Are you aware of the cost?
Applicant instruction.
Take instructions. We will not immediately burden you. You might have to, but you take instructions for it, okay? Third, Bora. MK Bora learned concept for the appellant. Full stop. Wide order dated 5/6/2024. This court, after noticing that the steps towards service of notice, which was taken by Dusty, was served upon the brothers of the respondent, And accordingly, this court had directed taking of fresh steps by Dusty. Full stop. The learned counsel has submitted that pursuant to the said order, fresh steps by Dusty has been taken, whereafter an affidavit has been filed on 3/12/2024. It has been stated in the affidavit that as the respondent was not available, the notice was served on her father, who had duly accepted the said notice by putting his signature. Full stop. The said acknowledgement has also been annexed to the affidavit. Para? Since on the earlier occasion, dated 5/6/2024, this court had made an observation that steps in a matrimonial case is to be served personally, the learned counsel has prayed for some time to obtain instructions on the aspect of serving of notice through paper publication. Full stop. Para? The prayer appears to be reasonable, and we accordingly grant 2 weeks' time to Sri Bora to obtain necessary instructions in this regard. Please after 2 weeks.
Item 6.
This conviction is under what? Madam Begum, conviction is under? Non-appears for the appellant on call. Para? Oh, no, not so para. Where is Miss A. Begum, learned APP is present, para? The paper book being present, being prepared, the appeal is directed to be listed for hearing in its turn.
Item 8.
Item 8. Yes, you are for whom? Hmm? Okay. There are two, okay. Yes, what is to be done? Why is it tested? I is for delay condemnation.
Yes.
Notice was issued, thereafter steps were taken or not? Still not provided the form forwarding form. What is your name? Your name is not there. Third, Miss Tinglung, learned counsel appearing on instruction of Sri N.K. Murray, learned counsel for the appellant applicant. Applicant. In this application, praying for condonation of delay, notice was issued on 15/12/2023, pursuant to which steps were taken by the learned counsel. However, office note dated 25/9/2024 had indicated that the required form which is required, that the form which is required to be attached with such steps were not filled up. And accordingly, the notice could not be dispatched. The subsequent office notes dated 21/3/2025 and 21/4/2025 has reiterated the said status. Sarah? Mr. Inglo, the learned counsel, however, submits that the necessary form would be filled up within a period of 3 working days. Sarah? The matter accordingly stands adjourned and is directed to be listed after 6 weeks along with service report. In the meantime, the steps as assured is required to be taken within 3 working days.
Item 9,
Please, your lordship, of the petition is there, so it was issued and it has stopped.
You have appeared. How many days?
60 days.
Objection? Okay. Heard. Ms. B. Sharma, learned legal aid counsel for the applicant who has filed this application under Section 5 of the Limitation Act for condonation of delay of 60 days in preferring the appeal. Full stop. The appeal has been preferred against the 7/3 order of asylum. Para. Notice was issued on 7/3/2025. Pursuant to which, pursuant to 2025. Full stop. 3. Miss A. Begum, learned APP, has appeared for the state respondent. Full stop. Further, Miss L. Devi, learned legal aid counsel, has submitted that she will be appearing on behalf of the respondent number 2. Full stop. Both the learned counsel for the respondents have submitted that they would not have serious objection to the aspect of condonation of delay and would rather oppose the appeal on merits. Para. It is a settled position of law that a petition for condonation of delay is to be taken in a pragmatic and justice-oriented manner. Full stop. We have also reviewed the reasons cited for the delay, which appears in paragraph 4 of the petition. Full stop. That apart, the appeal itself is against an order of conviction and sentence. And therefore we are of the opinion that the delay is required to be condemned, which we accordingly do. Full stop. The I accordingly stands allowed. Full stop. Let the appeal be registered and listed for admission after a week.
item 10,
Yes, you had sought for adjournment. He sought for adjournment. Okay. Okay. A prayer for adjournment has been sought for on behalf of the appellant. Full stop. Also heard Ms. A. Begum, learned APP. And your name? MS Hussain, learned counsel for the respondent number 2. Para. The matter accordingly stands adjourned by 2 weeks. IA was for what? They have filed objection or not? Yes. No objection. Then we can, why are you seeking time? We can condone the delay. How many days? 198 days. Why are you seeking time? They are not having any objection. What is your name? Huh? A.H. Mullah. On behalf of R. Islam. Okay. Okay, order. Huh? About it. Which paragraph? Paragraph 3 and 4. 3 and 4. Paragraph 3 and 4. Okay. And conviction under? Under to point now, the IPC of conviction sentence. Okay, okay. We are condoning the delay. Should come prepared. And matter will come, the appeal will come for admission after a week.
11. 11.
Chaudhary? First time. Part 3, RKD Chaudhary. Leonard. What do you, huh?
Yes.
Leonard. FDSG. Who has filed this application under section 5 of the Limitation Act Graduate Students for condonation of delay of 57 days in preferring the connected appeal. The appeal has been filed against students. Let notice be issued returnable by 6 weeks. Let steps be taken for service of notice upon the two respondents in the manner prescribed. There are steps within 2 working days. Dusty in a criminal on the first day. You can inform them in the court. The learned counsel for the applicant may inform regarding the present appeal and the application to the learned counsel for the respondents in the trial court in which the trial is said to be pending. We can fix a date if you want. Let list this matter on 6th of December. Today is 25th. 1, 2, 3, 4, 5, 6. We'll have it on 2nd of June. Is it okay?
Yes.
2nd of June. How many days delay?
No, this is.
No.
57.
How many days delay? 57.
Item 12.
Yes, Mr. Paul, what is this? First time. Matrimonial appeal. Okay. A Paul, huh? The appeal has done so. How many days? 78 days. The connected appeal has been filed against Wenzel. Issue notice. Returnable by 6 weeks. Let steps be taken for service of notice by registered post PTD within 2 working days. List up to 6 weeks for service report as well as for filing of objection, if any.
Item 14.
Only one thing. You can highlight only one thing, not more than one.
Against the secondary judgment, my lord, there are 2. One is the conviction. And so far the appeal against convictions are something like the Baku payment. And so far the appeal against
You are for the informant.
here, that was part-time in 201 days, and you also already issued notice. And the other side of all this, here for that's one number 4, 6, and 7. And it's from number 1 and 2, Some of them,
They have been acquitted.
yes, correct. So. If we for be allowed and we are filing my law, every register and my law, any day my law.
No, the hearing we can hear on a single day, but this hearing are on different aspects. He'll be arguing on the part of conviction of his client, and you'll be arguing on the aspect of acquitting the other.
My law, this particular case.
How many witnesses?
16.
16. No, for the sake of convenience, we can discuss the evidence in one go, but the decisions will be separate.
Now, what I'm pointing out is possible matter. It might not pass its any judgment, right? But this you are getting. Ultimately, in this particular evidence, the same sort of evidences are there.
No, that is what we have indicated. That is what we have indicated. So far as the discussion of the evidence is concerned, that will be a common thing for both. But we do not know what Mr. Decca would be emphasizing and what evidence he would be emphasizing. Because while resisting their present appeal, in your appeal, you would be arguing on why the persons who have been acquitted should not have been acquitted and should have been convicted. So in your appeal, your emphasis would be on those evidence which are mainly against the acquitted person. But if you say, Mr. Decca, we can, but the application of mine will be different for his appeal and your appeal, entirely different. But for the convenience of the court as well as the parties, we can have a common date so that 16 evidence can be read, cannot be repeated. What is the stage of your appeal? What is the stage of your appeal?
Because
No, delay condoned.
no.
Who has appeared? And are you appealing? Okay.
And 2 and 3 is his signed program.
Mr. Decca, you have got the information. You have got the information. No. We are indicating, though the acquitted persons are different,
My son, but this.
though the acquitted persons are not the persons you are representing now, they are connected and they are relatives most likely. So you can get the instructions unofficially. And if you are instructed to appear, very good. We can have this after 10 days. Okay, along with that case.
Okay, I'm against the conviction, and I was not representing against the acquitted.
Correct.
What happened in this matter of? What's called it? It can be happened.
No, he needs to have the instructions whether he can appear. He has to have the instruction because the persons who he is representing are not the same person who have been acquitted. They may be son, daughter, but they may have their other counsel. They have to be given that much of liberty, make an engagement.
Medical report of the president, short for yourself, and medical reports doctor records, working the suffering from severe breathing problem, some nerves problem. So my matter may be hard to learn.
We'll do one thing. We'll have this on Friday next. You get the instructions. And probably the delay condemnation, as you know, we are liberal and criminal appeal, the approach will be slightly more different. So,
but delay will not support against acquittal, not against conviction.
and a conviction is your case.
Yes.
We are not on we are on the aspect of his delay condemnation qua the appeal against acquittal is concerned. But nonetheless, both sides, we may not be very strict in condoning delay. He has the right to be aggrieved by the aspect of acquittal. You also have the right to be aggrieved by the conviction part. We'll have it on Friday. You get instructions. What is the case number? Please give it to your colleague.
I number is 51. 25.
Okay. Third, 3, P.K. Decca, learned counsel for the appellant. Also heard Miss A. Begum, learned APP. Full stop. 3, Chaudhary, M.H. Chaudhary, learned senior counsel. Assisted by?
Yes.
Huh?
Yes, sir.
T.N. Chaudhary. He is present for the respondent number 2. Full stop, para. Before the learned counsel for the appellant would advance his arguments, comma, Sri Chaudhary, the learned senior counsel for the respondent number 2, has informed this court that by the impugned judgment, while certain persons were convicted, certain other persons were acquitted, and the present appeal pertains to the aspect of conviction only. He has also informed that so far as the acquittal is concerned, his client has preferred an appeal before this court, which, being barred by time, is accompanied by IA number 333 of 111 of 2025, in which notice has been issued on 12/2/2025. He has also informed that in the meantime, few of the respondents have also entered appearance. Full stop. Para. Though a challenge against an order of conviction and a challenge against an order of acquittal, though maybe by a same judgment, is required to be considered independently, comma, for the sake of convenience, we adjourn this matter and direct the same to be listed along with criminal IA, 111 of 2025 on Friday next. Full stop.
I is always.
111. Today is listed over. Okay. Oh, no. No, your case.
I is listed, I is listed, after consideration of delay, it's appeal, but appeal is not numbered.
But why in a criminal level 30 of 2024? 30? No, how can it be 30?
Same appeal is. They are appealing.
No, their appeal is 30, isn't it? Your appeal cannot be 30. Not serial number, in the cause list. Can you see the cause list?
Was this kind of this same amount that was only. Ours is not numbered, it was. Number.
Is already fine, which is also listed today, Which is also listed today. That's our last opinion. Individual.
For the sake of convenience, adjourn this matter.
Urgent matter, so as to enable Sri Dekar, the learned counsel for the appellant, to obtain instructions as to whether instruction with the aspect of appearing to oppose the prayer in criminal appeal 111 of 2025. List this matters on today is 5th. We'll have it on 13th. You get most, no, not 13th. On 6th.
Yes.
Okay. Till 6th. You get some more time. You give a copy. We are not saying anything. Mr. Chaudhary, Mr. T.N. Chaudhary, give a copy.
I wanted this standing equator and so that I could communicate with my client also. I would.
No, see, whether you know, you have to know, but the admission of the appeal is almost a matter of right. So, condonation part, you can take instructions, but as you know, in all probability, you are going to condone the delay.
Yes.
So, you be prepared on the merits of the case.
Yes.
But you definitely you have to take the instructions. Without the instructions, you cannot.
Yes.
Okay.
Can it be the hearing is the top of the list?
No, let it come. We'll decide. Don't worry about the aspect.
Okay.
And Mr. Chaudhary, since the paper book has been prepared, you can get a copy of the paper book either from your colleague or from the learned APP. And so that you are also prepared. Because we do not want to spend more time in exchange of paper.
Yes, otherwise judicial is said by law, and two and three is white and some white. And others are getting.
The conviction is under what? 302. Who had died? Who had died? Who passed away? Your brother. What, mutual fight or what? So there was a fight on both the sides.
Actually, what happened by law in this case, we are having our photo plan. And even our photo plan, they have.
Entered.
etc. And they have attacked us, one person died, and one minor, is our brother, he has been seriously injured. And thereafter, the minor has also eloped from that place. And whereabouts is not known. And photos of issued. After long interval by we have also charged of this address. And we have given the address in our disease and also LAP. Because there was the one my lord, it was the injured person along with.
Was there a cross case? Was there any cross case?
No,
No cross case.
no. When we were forming because electoral commission, they will taking territorial instruction if you also basis for the electoral commission.
No, you need to file your Okalatama.
Yes.
We cannot.
Yes.
The procedure has to be followed.
Yes.
File your Okalatama, we'll remember your submission. Wakalatama. You cannot give, don't give instructions about the Wakalatama. Don't take the risk.
Today we'll file. Give them.
Yes.
Our lordship, the English council for this, thing. BRS, negative council. Just sick, so it not appear before the Sunday.
Okay, we'll have some other date. Okay. After 2 weeks.
It's ready.
2 weeks. Okay. A prayer has been made on behalf of Ms. B.R.A. Sultana, Learned Legal Aid Council, for the appellant for adjournment as she is unwell. The said prayer has not been opposed by Ms. A. Begum, Learned APP Para. But the matter accordingly stands adjourned by 2 weeks. Hearing them?
Hearing evidence, which I also do.
अरे नॉलेज वाले लोगों का पहले तक की पहले जाएगा
So I through details, I can let. Yeah, that is.
For example,
One, I took this.